Well, happy Tuesday night. I'm just going to go ahead and jump in though, because this one might be a little bit long, but it's very interesting in terms of Vanzan Sham lawsuit and its sham subpoena. I don't want to spend a whole lot of time chatting because it is kind of going to be a long one and has a lot of legal steps to it and stuff. It was just decided less than 2 weeks ago, and then a new part of it filed on Friday. So this is brand spanking new, but it's so exciting. And thanks for joining, Christina. I didn't message her again. I'm so awful. I don't know why she still comes here for me. But this involves so many things. We have a representative, Nancy Mace. We have huge accusations, and we have a very abusive Doe lawsuit used very much the way that Blake and Ryan used theirs. And I'm hoping that with these new cases being put on the record, that more things will be done. I really hope that these situations of this blatant abuse of this Doe lawsuit process, I really hope that it brings stricter regulations because it's crazy what people are out there doing. And now I had already wondered when I found out how this happened with Blake's case, how many people have done this. And now after seeing a second case, I really do. Even the Stans, Blake Stans, who insist that there was nothing wrong with the Doe lawsuit, that it was a loophole, that it was clever lawyering, they're going to find out. And I hope they read this case and get ready for what's going to happen in Blake's case. That is, if the judge rules correctly. We'll see. I think so too, Christy. Christy says, I'm sure that Manat Law Firm utilizes it all the time. I have a feeling this was not the first time. Why would you risk doing something like that for the very first time on such a big case? It's just too risky. You would be a little bit scared doing it the first time, I would think. So it really does make me wonder how many times this has been done before. And I wonder if this case that we're going to review today may have gotten the idea from Blake Lively. With the timing of it, it really could be. The reason we don't see so much out there about Doe lawsuits being abused is because Doe lawsuits are supposed to be what's called pre-action discovery. That means not the way Blake did it, but before a complaint is filed, there is a petition that you petition the court. And we're going to go through all those steps and what they mean. That means, though, that it's really it's easy to find Doe lawsuits to show how they're actually supposed to go. And I've done that before. But to find some that have been bad and been called out for it, that's a little bit hard because it's all in pre-action discovery and not actual easy to search cases. So it's been really hard coming up with them. I have another one that happened, I think, in California, but I'm doing this one first because this one is so very similar. But if you're wondering where I've been, that other one I'm working on and this one, these are like days and days and days of research. It's been really hard to find everything I needed to find and to back it all up. So I hope to be able to put this simply and clearly so you guys can see. I agree, ocean exploration. They say because the New York Times told them to do it. I would not be the slightest bit surprised if they had something to do with it. And I really hope that it gets discovered if they did. This is what made me so angry about Judge Lyman granting them the stay on discovery, because he told them way back that he pretty much expected that he was going to grant their motion to dismiss. And so he granted their stay of discovery, which meant they never had to turn over one page of discovery. And that's just crazy to me. How, with the accusations out there, I mean, at least collect some discovery, but they got nothing. And that really stinks because I agree. There could have been the involvement. They could have instructed. They could have known. They have a huge legal team that is supposed to cover these kinds of things. Even for myself, if I were told these things came from a lawsuit, I would not only ask the person giving it to me to show me a copy of the lawsuit, but I would look it up in the actual court records myself to be sure that it was a real court case. How did the New York Times let this get by their entire legal team? It doesn't make sense. So this lawsuit, well, let's do some background. What brought this lawsuit about in the first place? So on February 10th, 2025, Nancy Mace, who's a congresswoman, delivered a speech from the floor of the U.S. House of Representatives. It was a speech as part of her efforts to pass the 12 bills that you see on the screen. They're all about protecting women. And she surprised a lot of people when she began speaking about something that happened to her personally. In this speech, she introduced the names and photos. And just like this big board you see up on this easel, that gets replaced by an even bigger board, and it has the names and faces of her ex-fiancé Patrick Bryant and 3 of his friends and or business partners. She accused all 4 of them in detail of voyeuristic behavior, including allegations involving minor victims. It got even darker when she accused them of drugging and assaulting multiple women, including wives of their friends and partners. She claims that she came across these videos and pictures on her ex-fiance's phone. As she was going through them, she claims that she found a video of it happening to herself. So these were some very big, very dark accusations. And we're not really going to focus on the politics of any of it or the allegations. This is about specifically the Doe lawsuit. Now, this case is far from over. There was a third-party complaint that was added last Friday, but the Doe lawsuit part was recently ruled on. That part is over. In the new complaint, Patrick is claiming that it was all part of an elaborate plan that she put in place to gain the upper hand in their breakup so that she could get ownership of their properties. Now, again, I'm not advocating for either side in the matter. I don't know much about the details other than what we're going to go over today. I do have an opinion right now. I'm not going to go out of my way to voice it very strongly. I think you'll see it a little bit later. But the point of this story, like I said, we're just focusing on the Doe lawsuit aspect of it all. There are actually 2 Doe lawsuits in this one case. This one is a normal one. Oh, wait. Is that the new one? No. This is his new lawsuit against her. Sorry about that. This is the one I was talking about. So this is what a Doe lawsuit is supposed to look like. So what happens? She gives this speech, and as you can imagine, these 4 guys are, wow, they've just been accused of these things. So what happens? 10 days later, Patrick, the ex-fiancé, files articles of incorporation for an LLC. And this is where it starts to look like Vanzan. If you look at the date, you see it's her speech was the February 10th. He does this February 20th. And he opens a company called GLT2 LLC. Doesn't really give much information other than The company's agent, his name is Dustin Ham, which I don't know if that's a real person or not, but I thought that was a fun name. With this LLC, this brand new LLC, the next day, he files this petition to authorize depositions and discovery before action. And this is the way Doe lawsuits are supposed to look, how they're supposed to operate. We're going to get into the details of that. But he claims that this Jane Doe and John Doe are he knows that they're residents of Charleston. And look at what he says the purpose of this action is to do. It's to perpetuate investigative discovery, for example, depositions and discovery subpoenas, in order to determine the individuals involved in committing tortious acts against the petitioner. So he says that he expects to be a party to the action, but he's presently unable to bring it or cause it to be brought, and needs to be able to collect evidence regarding the statements in question, such as to be able to identify the specific claims to be brought and the specific parties to be named as witnesses. So he wants the court to perpetuate discovery by deposition, testimony, and discovery subpoenas. He says he needs this to determine the individuals that are involved in committing tortious acts. He says he brings this about under Rule 27. Rule 27, he's referring to Rule 27 in the South Carolina state statutes. So this is how you go about pre-action testimony. A Doe lawsuit, by its own nature, is pre-action discovery. You don't really have a proper complaint if you don't have a proper defendant yet. So this is how a Doe, and I've gone through this process before. This is how it's supposed to be done. You are not supposed to just go file this complaint. You're supposed to file a petition for pre-action discovery. And this lays it out very, very clearly. I love how the laws are laid out so well in South Carolina. So it's done before the actual action, and it explains that what you have to do is you have to show that the petitioner expects to be a party. You have to show the subject matter, what the lawsuit is about. You have to show the facts. What are you trying to establish with this testimony? What are the reasons that you need to perpetuate it? The names or a description of the persons that he expects will be adverse parties and their addresses so far as known. In other words, you may not know exactly who someone is, but you're supposed to put what you know about them. Now, it also says the substance of the testimony which he expects to elicit from each, and shall ask for an order authorizing the petitioner to take the depositions. We've talked about this so many times about why a Doe lawsuit operates the way that it does. In regular lawsuits in New York, most states, I'm not sure which ones do and don't, once there's a lawsuit filed, attorneys can write their own subpoenas. They don't have to get a court order for every single subpoena. But why is that? Because in a regular lawsuit in New York, the rule is this: for every subpoena that you send out, every other party in the action gets a copy of that subpoena. So everybody knows who you are subpoenaing. And you've seen a subpoena is not one piece of paper. You've seen they're thick, they're long. And it shows when I say this is what I mean. And this is the specific name searches I want you to, I want to show up in the search. It details, it's very, very detailed exactly what is wanted in that subpoena. The scope has to be narrow. Everything has to be explicitly described and laid out. And every person gets a copy. There's protection in that. That stops someone from putting out overbroad subpoenas, inappropriate subpoenas, because there are a million other eyes in the case looking at it. So, for example, in this case, for every subpoena Blake sent, All of Wayfarer attorneys got copies. Jen Abel got a copy. Jed Wallace got a copy. Stephanie Jones got a copy. Everybody got a copy. So everybody can see what's going on. When you're talking about a pre-action, like a Doe lawsuit, there is no opposing counsel. There is no one else that's going to see that subpoena. And so because of that, as a protective measure, it is a requirement that there must be a court order. Because there's in a regular lawsuit, you don't start sending out a subpoena until after everybody has met and conferred. And then you have to submit copies to each other. That's why it's okay for an attorney to go ahead and write a subpoena at will. But in this situation, as in Vanzan, if there's nobody watching, there's nobody making sure that your subpoena is not overbroad, does not ask for things that you have no right to ask for. So that is the reason behind it. And if you're smart enough, you can sort out why Vanzan was so wrong. And if you're not trying to stand for Blake, it's easy to see what is so wrong about it. Then it says that point 2, the petitioner shall thereafter serve a notice upon each person named in the petition, like we just talked about. You have to give 20 days before the date of hearing if the person has to appear for something. And if the person that is being issued the subpoena does not have an attorney, one will be made available for them because they need to be represented, and there should be someone there to cross-examine the deponent. So when you send out a subpoena that you want to depose someone, there needs to be someone on the other side there. And you remember when Justin was deposed, do you remember it all happened at Manat, and there was this huge group of 8 or 9 attorneys, they said, all walking in, though it's their law firm and they should have already been there, but they're there just to make sure someone is well represented. And then one point that's clear in 4 is that for it to be admissible, it has to have met all of these criteria. This is the federal Rule 27. And a lot of times with states, you will find the corresponding number, the same number, from the federal rules into the state rules. And more often than not, they are very, very similar in nature. So this is the federal one. And if you go through it, you can see it's almost word for word exactly the same as what South Carolina says. Often, the federal rules are very similar to most states. So I just put that in there to show that even though this happened in South Carolina, there are good reasons to believe that it also applies in New York, and that's what we're going to get into. Now, New York has their own way of numbering their civil practice laws and rules we call CPLR. So they are not Section 27. I believe it used to be, but they revised their laws and they're laid out very, very weird. They do things so different there. Oh, interesting, Ocean. Ocean Exploration says Wayfarer recently found out Lively did 22, perhaps 23 depositions when they both agreed 20 max. It wasn't just an agreement. It was what the court said. Normally, each side gets 10, but because there were so many plaintiffs and defendants in this case, he granted them 20 each. Once you get to that 10, or in this case 20, you are not allowed to just go depose whoever else you want. You have to request permission from the court. So if she did that, she was outside of the court's rules. That's interesting. Okay, so New York's rule on this is Section 1024. And look at this compared to 27, both in federal and in South Carolina. This is so basic. There's not much detail here at all. But it does say what you have to do. You can proceed against such person as an unknown party by designating so much of his name and identity as is known. In Blake's case, she knew she was serving the subpoena on Stephanie Jones. Stephanie Jones' name should have been there. She knew that she wanted the contents of Jennifer Abel's phone. Jennifer Abel's name should have been there. This is New York rules now. So this is her first breaking of the New York rules. She knew she was sending it to JonesWorks, Stephanie Jones, to get Jennifer Abel's phone. Those names should have been on there according to New York law. All subsequent proceedings shall be taken under the true name, and all prior proceedings shall be deemed amended accordingly. So what you're supposed to do is start the suit, get this pre-action discovery, keep it in the same court, the same lawsuit, and you just amend it. You just add the names as you learn them, just like you add information as you learn information and you amend it. That's what she was supposed to do, straight up out of New York law. Now, that being so basic, does that mean that it's okay to just, that's the only thing you have to pay attention to, that you can just now go willy-nilly and do what you want as long as you do those few things? No, because CPLR is not the only rules that have to be followed. Of course, it's the starting point in a civil case, but there are many other things to turn to that you have to be in harmony with. For example, the NYCRR, or it's also known as the Uniform Rules. For this topic, it's NYCRR Part 202. There are also local or commercial division rules, such as the Southern District of New York has its own rules. You have the judge's rules. There's also case law. There are legislative materials. So like when I was showing you how 47.1 went from a bill to becoming a law, I went through those videos because I wanted to understand. There's not much written about it. It's never been used in a court. So I wanted to understand how it came to be. What are the ins and outs of this rule? So I went through the legislative material. That's what you can do when you are, sorry, David, maybe giggle. When you are in doubt of how to proceed, there are so many different ways that you can do this. You can invoke the court's supervisory powers, what we know as inherent authority. You can say to the judge, "Judge, honestly, I'm not sure how to proceed here. This is my situation." And you can ask the judge to tell you how to proceed. There are so many ways to do this. You also have your professional responsibility rules. What do you have to answer to for your state bar as an attorney? So just because this section 1024 of CPLR is very, very basic, doesn't give a lot of information, doesn't mean that you can just do what you want. So that the uniform laws we talked about a moment ago, the NYCRR, section 20220D specifically talks a little bit more about subpoenas. So this is one place they could have looked. Manat's a huge law firm. They've got so many attorneys. Somebody could have opened a book or opened their computer and found the rules to know that Vanzan was a sham. So this specifically talks about if you do not have the identity of the person that you are trying to subpoena. It also mentions in these rules, CPLR 3106D, you give as much of the identifying description as you can. So for example, an employee of, officer, director, member, there are so many things that Manat should have included. Like I said, Stephanie Jones Works. We want the information off of their former employee, Jennifer Abel's phone. All of that should have been on there. And it must advise the non-party entity of its duty to make the designations discussed in this rule. So back to this one. This is what he did. He filed this petition to authorize depositions and discovery. On the right, we have the judge. This is what happens next. So you don't just say, hey, I want to write these subpoenas, check yes or no. You submit this petition to the court. A judge gets assigned to oversee it. And we know that Blake did not, or Manat did not ask for a judge to be assigned to their case. They didn't wait for a judge to be assigned. They quickly, immediately sent out a subpoena. That's what they did wrong. This is what you're supposed to do. Look what the judge says. There's a decision by the court. This matter is scheduled before the court on April 3rd, 2025, pursuant to the plaintiff's petition to authorize depositions and discovery before action. So, how does it go? Just like we've been saying, you have to have a hearing before the judge. The judge decides whether or not you get to proceed. Now, something interesting happens here, and this is where we start to feel a little funny about what's going on. In the meantime, between the petition being filed and the judge making this ruling, he asked for a continuance. So the hearing, you'd think he's eager, he wants to get this started. It gets scheduled on the 3rd, and then there's this request, and so it gets granted. It's going to be continued. So that's just the beginning of his tricky behavior. This is a little out of order. This is the final sanctions order. This is what was just decided on October 30th, but we can kind of use it to give us a timeline of what happened. Because as we've seen a lot, the judges, when they rule on something, when they issue an order, they do a lot of background about the case, about how things came about. So this is what he said: because Rule 27A3 requires a court order approving the requested depositions, the clerk's office scheduled the petition for a hearing on April 3rd. However, on April 1st, 2025, an order of continuance was issued because petitioner requested a continuance to attempt to resolve the petition. The hearing was rescheduled for June 4th, 2025, but again, continued at petitioner's request. So this guy's like, I need to get this started. Here's my petition. And then he's like, wait a minute, I need more time. A second time, wait a minute, I need more time. Now it's gone into July. Here is the order where he grants the continuance when it was scheduled for June 4th. And this is what takes it into July. And he says there are no opposing counsel in this matter, and the petitioner is currently finalizing the discovery. So as far as the judge knows, nothing's happening. He's still getting himself together, and then he's going to come and he's going to get permission. The judge will decide, and then he will issue the subpoenas. But look what this sneaky little snake is up to. Look at the date of this deposition, April 28th, 2025. So there was a hearing originally scheduled for April 3rd. That gets continued to June 4th. That gets continued again. But this busy little dude is deposing people on April 28th behind the court's back without having a hearing in front of the judge, without waiting for an order that says you can depose people. And for any of you that were from my Murdoch crew, you recognize this guy because I've always called him the cheese butt. His name is Wesley Donahue, and he calls himself a knife fighter. He is the South Carolina version of Jed Wallace. He does a lot of PR crisis management. He works for a lot of politicians, actually. And so he had something to do with Nancy Mace and also her ex-fiance, Patrick Bryant. In fact, the two of them were better friends. We're going to learn a little bit more about this guy. Up till now, I've always just called him cheese ball, cheese butt, and I've always felt a little bit bad about it. Like, what if this guy's not so bad? But I think I need to find a new and worse name for him now. Maybe you guys can help me. We'll see when you hear all this. So what he does, like I said, he works for political candidates who need help establishing or cleaning up their reputations. He's the messy man. He is like PR on steroids. So he was deposed. Let me see. I've gotten ahead of my notes now. I do that. And remember what we saw. I had highlighted it in green. There are no opposing counsel in this matter. Do you remember that? That's important because that means that this man was deposed. He had his counsel there, but there was nobody from the other side present. And that's a problem because there's no one to question what this guy's claims are. So this starts to get very, very messy. And then it gets even more messy because guess what happens? Just like with Blake and Vanzan Sham, What do you know? A newspaper article comes out. Post and Courier is a South Carolina newspaper. There's two main ones, the State and Post and Courier. So then this is Patrick Bryant at the top, one of his social media platforms. But he says, oh, a new article out today in the Post and Courier detailing sworn deposition testimony from Nancy Mace's former campaign strategist, Wesley Donahue. And he misspelled his name, by the way. It's an E, it's spelled weird. But then he ends up telling all of this. Now he's just repeating what's been put out in an article. So he's keep making sure. Now, if he'd just come out and said all this stuff, he'd be in trouble. But he makes sure it gets leaked, it gets put in the paper, and now he's free to talk about it without being at risk because he's quoting from someone else, which is so very tricky. But it leads to one really, really big question. How did the Post and Courier get this deposition that not even the court knew existed? Only this LLC that he created and Wesley and whoever was there present for that deposition even knew that this deposition took place. Now, what does he proceed to do? He proceeds to tell what Wesley said in his deposition. And this is what Wesley alleges. He says that Nancy believed that Patrick cheated on her and had pictures of women without their consent, and she sat on that information for well over a year, did not want to contact authorities, and asked me to blackmail Patrick Bryant. So see what's happened here? Normally, it's a lawsuit. You have to wait. You have to wait a long time. We've seen that happen. And just like Blake, she wanted her reputation fixed now. So what did she do? She went to the New York Times. She got this weird Doe lawsuit, got the information, ran to the New York Times, and guess what? It's instant character fix. Oh, I'm a victim now. Look at these bad people and what they did to me. But if you do it properly, you have to sit back and you have to wait for the lawsuit and hope that you win, and that in the end, the truth will come out. So this guy, and I really do believe, look at the date, May 23rd. This Blake Lively lawsuit was well along by that time. I really feel like they said, oh, look at this. We can do this. It worked for Blake. The attorneys online are saying, this is brilliant lawyering. They're saying, this is a loophole. We won't get in trouble for this. Look, nothing happened to Manat. Let's give this a whirl. I really wonder if that's what happened because of the timing. So this is exactly what he did. He files this fake Doe lawsuit, gets this deposition without anyone overseeing it, gets this guy to say all this stuff, slips it into the newspaper, and now he can run about and say, look at this horrible woman, look at what she did to me. And so the accusations against her continue, that she did all of this because she wanted the properties and they were splitting up. And do you remember what I said back in the very beginning when I said the dangerous thing about these Doe lawsuits? Being abused in this manner, who is going to suffer? Who suffers the most in every situation in life, in every corner of this earth? Women. This will be used as a weapon against women. If an abusive man, if his ex has run off and hid with the kids out of fear for her life, because 3 of us get killed every single day by our partner or ex-partner, and the police don't seem to care about that, so these women are off hiding, guess what you can do? You can get a PI or someone that might know her and get them to do the tracking down, and you can slip them a Doe lawsuit, get the stuff you need, bring them to court, make them bring your kid back. You can do, stalk somebody. You just need an unscrupulous attorney that will do this for you and try to use it as this loophole, And in the end, this will be, just like in this case, women that get targeted the most. Mark my word. This has got to stop. This whole abuse of process is horrifying. And it was put out there by the woman who claims to be the voice of women, who has yet to speak for a single woman except for herself. So this woman has Nancy Mace has put this information out there and said this is what these guys were doing, and this is what happens. Someone abuses the legal system to get this information, and then it's out there in the paper, and shame on Post and Courier for printing this. And before Post and Courier, it was Fitz News that got it and put it out. They see this deposition and they don't question anything about its origin. What lawsuit is this from? They don't do their due diligence and look it up and see if it was a deposition done correctly. Nothing. They just get it out there for the clicks and views. And then it gets picked up from there because now the newspaper can do it because someone else posted it already. So they can quote from that newspaper. They can show that deposition that's already out there in the public, and they can do it. And now this guy turns around and takes it, and look what he does with it. So all this time now, guess what happens? People are like, oh yeah, she was lying. She was lying because she wanted property. She knew about that. She didn't care about those women. She hid that for a year because this guy says so. This cheese butt, this knife fighter. But once you get that story out there, how do you get it back? Exactly. Jungle Vet Jill says it's only a secret loophole as long as nobody knows about it. That's why I think it's a trick of MSM, because they can't be forced to expose their sources, so nobody knows how they got it. Exactly. I bet this has been used and abused for a long time. And that's what makes me very, very suspicious of this. This rule in New York, look at that tiny, undetailed, simple, basic little law compared to the federal and compared to the South Carolina. Are you serious? The state and city that have more lawsuits than anyone, we got little South Carolina took all this care to get all this out there. This is the federal, and this is New York. That makes me very suspicious. Very, very suspicious. Are they helping this along somehow? Do they purposefully make the law so simplistic and basic and not much information? It really makes me wonder. I don't like this. The more I dig into this, the less I like it. It's really, really bad. So in the meantime, I told you there are 2 Doe lawsuits. So this second one is an actual Doe lawsuit by one of the women that was identified from the videos that Nancy Mace found on her ex-fiance, or alleges that she found. Got to be careful because he's not been found guilty yet. That she alleges were found on his phone. She knew the woman. She shows it to her. She's like, look, this happened to you while you were drugged and unconscious, and there's video of it happening, and I think you need to see it. And so that woman, and she remembers the day, she remembers blacking out, but she had no idea what happened afterwards. And so she files a real Jane Doe lawsuit, but she didn't want her name out there. Of course she doesn't. That's humiliating. That's horrifying to find that out after the fact, that this happened to you and you had no idea that it happened to you. So she's like, wait a, I'm gonna do this. So she has this lawsuit going, and this gets filed on May 29th. So this is before there's been any hearing. Nobody knows he's out there deposing people and subpoenaing information. And so when she sees this come out into the news, she's like, what is going on here? And so she files to intervene. She asks for an expedited hearing, and she wants this dismissed, and she requests sanctions. Because why? Because this is an abuse of process. Just like Brian Friedman said, a Doe lawsuit's sole purpose is to identify a person that you have a case against. That is it. That is not what Blake used it for. That is not what this guy used it for. They both used it to access discovery that they could not get in a traditional way because no court was going to let this happen. So it introduces her as Jane Doe. She's an assault victim and she wants to proceed as the name Doe. And she's trying to intervene against this petition to authorize depositions and discovery. She wants that petition dismissed. She wants an expedited hearing to prevent GTL2. This guy's sneaking that in there so that it has nothing to do with his name, just like Vanzan, for these, as it says, unauthorized depositions and unauthorized discovery. Why is it unauthorized? Because it requires a court order, and it requires it in New York as well. There are millions of cases, not millions, that's an exaggeration, but thousands of Doe lawsuits. They all have that in common. They had to come before a judge, present their case, and some of them are granted, some of them are denied. Now, why would only some people have to do that and some people don't? Why? It doesn't, the law doesn't work like that. Okay, and so again, it asks for the petition to be dismissed, sanctions to be granted, and it says that GLT2 and its attorneys, the attorneys are this Brewer law firm, referred to as BLF, so when you see BLF, that's what it is, engaged in the following willful misconduct. Even though this court had not granted its petition, they issued a subpoena and deposed a witness. See, you can't do this. This is what Manat did. 2, they did that without any legal authority. 2, misled the court about the purpose for filing this action. Like I said, a Doe lawsuit is exclusively to find someone's identity, not to depose people like this. And 3, failed to comply with the state's rule. That's the South Carolina Rules of Civil Procedure, which sets forth the requirements to depose a witness before filing an action. Let me read this footnote. It says, Miss Doe is aware of one witness, Wesley Donahue, that GTL2 deposed. However, she believes there are likely other witnesses that they have deposed or intend to depose. They don't know. This guy's just out there, this law firm's just out there doing what they wish. And 4, failed to notice and serve the expected adverse parties as required. 5, failed to notify the court that expected defendants John and Jane Doe were unrepresented, so the court could appoint counsel as required. 6, continued this action to ensure that it could depose the witness even if the court denied its petition. We saw what happened to Blake's original. One of the first things she filed once discovery started, she filed a subpoena, served a subpoena on the Wayfarer parties for the contents of their phone. Do you remember? And it was way overbroad. And the judge was like, no, you can't have that. You have to narrow that way, way down. Do you guys remember that? So she knew that Manette knew that that was a risk. And so they needed another way to be able to get everything that they wanted to get with no one looking over their shoulder and nobody forcing them to narrow the scope so that they could just get whatever they want. And that's what is so wrong with this. 7, leaked the transcript of the deposition. So that's what I was talking about, which they knew contained false information about Miss Doe's claims to Fitz News and other media outlets. Fitz News is where Mandy Matney and Liz Farrell used to work. It's where they were working when they really did the beginnings of digging into the Murdaugh case. And there was bad blood and they left. And since then, they've gone from pursuing the truth as far as Alex being guilty to being kind of more. I unsubscribed a long time ago because they started serving the purpose of Alex's defense, because those are the ones that would give them information. But they got this questionable deposition and just put it to print immediately. And once one outlet puts it to print, all the others, like I said, are safe to report on it as well because they just cite their source and then they can't be sued. So this Fitz News was their version of the New York Times. They're the ones that were willing to put out whatever. Ocean Exploration asks, do you think Fitz knew about the legal origin? I don't know. I don't know, but the thing is, you should ask. You should do your research before you put something. These are some serious allegations. You should be sure that to the best of your ability, they're already being sued. They have another lawsuit against them as we speak for putting somebody's face out there. I covered the story actually last year. They put, there were some persons of interest. They weren't even legit suspects in a murder that happened in South Carolina. And they put the right name of the suspect, but they put the wrong face in the story. And I think they copied off of somebody else because there was another guy who had done that inadvertently. And he had put out a disclaimer, but he was the one that originally put out the wrong face. So it tells me, because it would be very, very difficult for two people to make the same mistake. It's kind of weird. So I think that he just like copied off of the other person and got that picture. So put that guy's face. Now, once everybody makes mistakes, I've made my share of mistakes on here too. But the thing is like you let people know that you made a mistake and you try your best not to do it again. So the kid's mom wrote in and it's like, that's my son. This is not who you're saying it is. Get his face off of there. And so they issued a very non-apology to the mom. And then a few months later, they did the very same picture, the very same accusation all over again. And so now they're being sued because that's just ridiculously careless that you make that same mistake twice. You'd think that after that you would be more careful. So yeah, so that's what's going on here. But just like the New York Times was ready, willing, and able to put her story out there, unfounded, unproven, sketchy subpoena, sketchy lawsuit, no question asked, just put it out there. And that's what happened here. So she's asking the court to intervene, dismiss it, and she talks about willful misconduct, reckless disregard of her due process rights, including, but not limited to, the right to a fair and impartial jury. Because once a salacious story like this gets put out, oh, this woman knew this story and sat on it for a year, people aren't going to forget stuff like that. They're going to form an opinion, and that opinion is, who knows if they're going to hear the story get straightened out, or if they're going to go on believing, oh, this is what it is. And it interferes with a potential jury then. And also the right to confront the witnesses against her. She should have been able to be there during this deposition. But because it was done underhanded, she didn't even know about it. Just like Jennifer Abel wasn't allowed to file a motion to quash the subpoena because she didn't even know about it. Okay, so here's what they did. This is Bryant and his sham company, GTL2, who knows what that even means, and then his law firm, BLF, failed to present any facts to the court explaining why it was presently unable to file an action. If they knew who they wanted to depose, why did they file the Doe lawsuit? It's just like Blake. She knew she was going straight to Stephanie Jones and Jones Works to get Jennifer Abel's phone, and he knew he was going straight to this man to get his deposition. And it gets even worse. He failed to file a verified petition with the name or description of the expected adverse party as well as their addresses, which is a required element. He knew this guy's name. He knew this guy's address. He knew this guy personally. There was no reason to say this is a Doe lawsuit. Just like Blake, she knew exactly where to find Stephanie Jones, but hid it in a Doe lawsuit. Failed to state the facts that they seek to establish through the proposed testimony, as well as the reasons for seeking to perpetuate it, which is required. Failed to specify the proposed testimony and the names of the deponents. So remember, in the rules, you're supposed to put as much of the information as you have available to you, but he didn't. Also requires the petitioner to serve and notice the expected adverse party, so they have the opportunity to appear before the court and be heard about whether the court should grant the petition. Didn't give her the chance. Failed to identify the expected defendants, John and Jane Doe, and failed to serve them. Then it talks about how this was supposed to be heard on the 3rd. They continued the action to ensure that they could depose Donahue even if the court denied the petition. So they weren't going to take the chance that they didn't have, because it takes a lot. There's a lot you have to prove to the judge to get this petition granted. And Manat knew that, and BLF knew that. And so they're like, okay, we're not going to risk it. We're just going to go in and we're going to get this information, even though they had no legal authority to issue a subpoena because the court had not granted its petition. They continued the petition so that the court would not have the opportunity to appoint counsel for expected John and Jane Doe defendants, thus ensuring that Donahue would not be subject to cross-examination. That's what I was trying to think up earlier. That's the thing. Depositions are supposed to be, there's cross-examination allowed. Remember the big fight about the deposition and over who was it they were going to depose, and they wanted to divide the time, and Blake's like, I'm going to go first and I'm going to get this many hours. And then they let the court know that Blake had been taking break after break after break and then running into someone else's time and leaving them. Menegave says, I can't wait for Vanzan sanctions and all the truth to come out. Exactly. Yes, it was the Sony guy. Okay, they mention again, no opposing counsel. They say that this is a clear admission that they were engaging in discovery, even though the court had not authorized them. They failed to notice or serve the expected defendants or advise the court that the adverse parties were unrepresented, so the court could appoint counsel. Because remember in the rule, if opposing party does not have counsel, the court will appoint someone for them. And what they were doing is finalizing discovery while the expected adverse party was unrepresented, just like Blake. The leaked transcript reveals the true purpose is to disseminate false and malicious information about Mace, a key witness in Miss Doe's case. The defense strategy is to attack Mace's credibility and create a false narrative by deposing her detractors and leaking the testimony to the public so that jurors will have a preconceived notion. Is this not the same case? I mean, it just really needs different names put in. It just sounds like we're talking about Vanzan. Now, here's the part when I said it was going to get worse. So BLF and Bryant deposed Donahue, who has been friends with Bryant and Osborne, who was one of the other accused, for over a decade, and is a harsh critic of Mace's. So this is what happened too with Blake. She knew that Stephanie Jones was mad at Jennifer Abel. Stephanie Jones was mad at Wayfarer. They teamed up, colluded behind the scenes, and did this. And that's what we've got here. This is his friend for over a decade. It's well known that Donahue has a grudge against Mace, stemming from a heated public exchange she had with U.S. Representative Trey Gowdy, who is a client of Donahue's. Since then, Donahue has made false and malicious attacks on Mace's character on social media. Here are some of the things that this guy's been saying. So it's obvious this guy colluded, just like Stephanie Jones did. I fired Nancy Mace as a client a few months back because I'm a political consultant and not a babysitter, an S therapist, or a doctor who can prescribe fixes for chemical imbalances. I don't have time for her constant egotistical BS and drama in my life. And I'm reading things more carefully because someone keeps reporting my videos. And even though I win, it takes a few days. And so, and most videos are seen within the first few days that they're posted. That's when you get the views. So by the time I get them put back up, the earning potential is basically over. So I'm trying to, I mean, I'm usually very careful with what I say, but I'm trying to be even more careful and trying to avoid that from happening because they're going to target this one since it's about Vanzan. Yeah, I was reported for what did they call it? Was something like explicit, inappropriate stuff. You guys know, I don't even say cuss words. But yeah, that's yeah, Rose is wild. I saw that. They ran Ashley off. She was so suppressed, it's ruined her channel. Yeah, like I mean, look at my numbers. 279. I used to have like 700 to 1,000 in here. People are not getting notices that I'm live or that my video is up. It's definitely it's Gelth asks, could it be Manat lawyers copy striking you constantly? That would be within their yes, I think I don't know who's doing it. That's the thing. You don't get to know. Yeah, Perez is down too. Popcorn Planet. Yeah, somebody's doing it. It's very coordinated and it's not copyright strikes because they um you get a big strike on your channel. Like you can lose your channel if you get 3 of those. And what happens is if somebody challenges your copyright strike, you have to pursue it. So it's a little more difficult to do a copyright strike because you have to show this is my material that was copied and I don't copy anybody's material. So they wouldn't be able to be successful with that. So they just say that I have inappropriate stuff on my channel, which is crazy. Like I said, I don't even say bad words. But okay, so it seems that I hurt Nancy's feelings. Can't wait for her to throw that victim card down again. It's her only play. A pitiful embarrassment to the South Carolina Low Country. In March of 2025, not long before they sought to depose him, he posted, "This is literally what Nancy Mace does every day. She's always the victim of some attack, most of which she completely made up in that chemically imbalanced brain of hers. Total trash, total nut job." So this is the guy, a Jane Doe strike. Yes, Jesse and Max. That's exactly what I'm getting. So this is what this guy was saying about her. He's been a friend of Patrick for over a decade, and he just willingly goes along with this questionable subpoena. And the weird thing is, his law firm went along with it. So everything about this just weird. Another thing he posted in April, just before the deposition, he called her a constant he said a constant victim mindset is for losers. She's a loser, always has been, always will be, total loser. So they're saying he has demonstrated a deep-seated hatred of Mace as well. This is where I was like, okay, we got to get a better name for him because he's not just a cheese butt. As well as a bias towards victims and women in general. In 2019, he stepped down from his company, Frothy Beer Brewing, for posting the following comments on Twitter and Facebook, reacting to Alabama's recent abortion ban. "We need more women running for office," Donahue wrote. "Until then, men will and should control legislative bodies." So he's a woman hater. So I think we need a new name for this awful man that I used to just think was cheesy. Now I know he's just a misogynistic. And then another quote very similar to the previous ones. "He and his lawyer knew, or should have known, that BLF had no legal authority to issue a subpoena as there was no pending lawsuit and the court had not granted GLT2's petition. This is what I'm talking about. Like I said, if I'm going to post about a lawsuit, I'm going to go to the actual website and make sure that lawsuit is on the books. What's a cheese? What's a cheese bud? Is that a kid? Too blue. A cheese bud is just I don't know, someone who's very cheesy. Did you guys didn't say that when you were kids? We used to say that when we were kids. What a cheese butt. If someone was like really, really cheesy, like embarrassing behavior. They should have known the deposition was unlawful because there was no opposing counsel present. An attorney should know that. They should walk in the room and be like, where's the other half of this? But they also should have looked up the lawsuit and seen that there was a petition pending in the court. How do you go represent your client at a deposition and not have looked up the case, not have gotten a copy of the complaint to find out what it's even about? There's no way. I can't imagine. That is just absolute negligence. And if he had gone in and looked up that case, he would have found all that was on there, all that was on the docket at the time was this petition. Okay, it is more believable that Donahue became unhinged when Mace attacked Gowdy and was a willing participant in BLF and GTL2's efforts to poison the well. At no time did BLF question Donahue about tortious acts against GLT2, as his law firm claimed in the petition to the court. That's why his attorneys should have had a copy of what is this about? What is my client testifying to? Is there a potential here for him to be accused of something? He should have had that complaint looked up, read, and a copy of it with him. But he didn't even bother because he already knew exactly what he was doing. Now here's the interesting information. Mace did not sit on the information for well over a year to blackmail Bryant. Now we've got the guy in an outright lie. How do we know this? BLF and GTL2 know that Donahue lied because SLED spokesperson, and SLED is South Carolina's state police, Renee Wunderlich, confirmed to multiple media outlets that they opened an investigation regarding allegations of assault, harassment, and voyeurism on December 14th, 2023, and that Bryant is the subject of the SLED investigation. So she didn't sit on it. She very quickly turned it over. It took her some time to get through it because she said it was terabytes of information. Some of the women she recognized, she was probably securing copies of it somehow to give to these women, probably consulting her legal team about how to go about doing this correctly. And then she took it to SLED back in December of 2023. So that's verifiable, confirmed to multiple media outlets that SLED themselves has said, we're investigating this. So of course they had copies of it in order to be investigating what if they don't have copies? How would they know about it if she sat on it all that time to try to get properties? Okay, so this is just repeating that she reported him to the FBI and to the United States Attorney's Office, and they turned it over to SLED for investigation. All the pictures, all the images, all the videos have been turned over. So that wasn't even true. And now this poor doe who finds out about it from Nancy Mace by showing her this video of her completely incapacitated and these disgusting men doing what they did and recording it. She doesn't know if it's been put on the dark web. She doesn't know how many people have seen it. And that's in addition to the fact that she was assaulted by these creeps. And so she's going through all this severe emotional distress. She just found out about it not that long ago. She's having panic attacks, crying spells, nightmares. She can't work sometimes. She's seeking help. This is true emotional distress. This is what true emotional distress looks like. And now she's got to deal with this guy with his sneaky depositions and his friends lying during these sneaky depositions to try to help cover him. Donahue's claim that Mace asked him to blackmail Bryant is ironic because, according to the text messages, Donahue was the one blackmailing Mace. Isn't that interesting? Very Stephanie Jones of him. On December 20, 2024, he texted Mace, "You do not want to pick a fight with me." Then he texted Mace a laundry list of the things he claimed to possess that he could use to blackmail her, such as embarrassing videos, texts, and Signal messages. Signal makes an appearance again, implying he would release them if Mace acted in a way he disapproved of. Yet nowhere in this list of things he claims to have on Mace does he claim that she asked him to blackmail Bryant. So one side has all the proof, and the other side has an abusive Doe lawsuit. So what does he do as this is happening? Uh-oh. So he quickly withdraws it, just like Ezra withdrew our subpoenas once we told the court, these are bad. These are not legally sound. And they're like, oops, let me just take that back and all will be well. So when he withdrew it, he canceled the hearing. He said, oh, it's no longer relevant. Look what he says. This is what this law firm who just did this says to the court. The conditions that existed at the time plaintiff submitted the petition no longer exist. Therefore, the petitioner respectfully requests a full dismissal of this matter. Too late, buddy. On the same day he filed that, he also files a motion to, in opposition, a memorandum in opposition to Jane Doe's motion to intervene, and tries to fight that. He files a supplement to that just 2 weeks later. And then we see a lot of back and forth go on. Nancy files her own memorandum seeking sanctions because this affects her as well. But I want you guys to look at something here that I thought was interesting, because in with the sanctions, now we haven't gotten to see this. I think this stuff all gets sealed. In with the motion for sanctions, the court asks them to submit all of their attorney's fees and things like that. So they submit this. And I want you to, I did some color coding here just to help see it a little more clearly at a glance. We have the yellow, which are telephone calls. The green is when they're analyzing, researching, that sort of stuff. Pink is when they're actually drafting motions. And blue is the emails. They only charge, because it's South Carolina, not New York City or LA, they charge $350 per hour. Now remember, some of Blake's attorneys make $2,000 an hour. And I think probably the minimum is $1,000. Look at how attorneys bill. Every last minute is calculated, whether it's a phone call or research or drafting, sending emails, whatever it is, they mark it all down to the fraction. And then they multiply that by the 350. So we see how quickly these add up. Now, this case went on for just under 3 months. It only had, let me see, I think I wrote all this down. It started May 21st. It ended August 19th. So just under 3 months. There was only one court appearance. There were only 13 documents filed. The rest of it are phone calls and emails. And it came to $34,181.74. And this is not a lot of attorneys. It's a smaller law firm. Now think about how many attorneys Blake has. Think about, we're up to almost 1,000 filings, and most of those, more than half by far, came from Blake's side. Can you imagine? And then think about the phone calls. Think about the phone calls with Blake and her word salad. Can you imagine how long her phone calls must be? They probably just put her on speaker and they sit there doing something else, watching Netflix, whatever, while she prattles on and on and on. It must be outrageous. So if you took this amount of hours and you paid Blake's attorney's fees, that would be just under 200,000 just for these 3 months with so little done. Ocean Exploration says the 5 years of it ends with us footage. Exactly. I'll never forget that. I wonder how far along they are in that. So that was just a little aside thinking about how big her how many millions? Probably tens of millions by now, I would venture to say that they're up to. Because I mean, they file huge documents. These documents weren't so long, but even them, some of them are like 5 hours to draft because it takes a long time. You have to do a lot of research. So imagine those ridiculously large filings that they've got that say a bunch of nonsense and how much each one of them must come to. It must be crazy. So of course he fights back and he files a memorandum in opposition to sanctions and attorney's fees. And he tries to claim that everything he did was just fine. Just like Vanzan. It's just fine. No, it's okay. The gravamen of Rule 27 is preserving the testimony for use in a later proceeding by securing a method for cross-examination. No, sir. It's to find the identity of the person you're trying to sue. It's not so you can go and get whatever you want with a subpoena that nobody has okayed and that nobody is defending from the other side. He's saying it's not prohibited. When a witness like Donahue has counsel and understands a Rule 27 petition hearing has not happened and agrees through counsel to comply with the subpoena by giving a sworn statement under oath in the form of a deposition, it's difficult to see what the prejudice is. You didn't let Jane Doe sit there. You didn't let Jane Doe be represented and cross-examine this liar, allegedly. Don't subpoena me, cheese butt. Truthful statements were obtained under oath. That's your interpretation. These witness depositions will ultimately be taken. Yes, they will be taken in the correct way. So why is he taking them now? Under cross-examination in the Doe case, in which case any alleged prejudice to proposed interveners would be cured. No, sir, because you took the deposition and you gave it to the press. And tens of thousands of people have read it. That's a huge newspaper in the whole state. It can't be cured. A Doe lawsuit is to find someone's identity. What about him making all these accusations against Nancy Mace helped you identify anyone? There were no questions. The whole deposition is available. There were no questions about anyone's identity. Just like Blake used nothing to identify anyone. All she did was get Jennifer Abel's the contents of her phone. The Donahue deposition illustrates another equitable reason that fees should not be shifted onto GLT2. That deposition was conducted after the issuance of a Rule 27 petition subpoena, where counsel for Donahue was aware the petition hearing had not occurred, effectively ratifying the taking of the deposition as a proper resolution to obtain the equivalent of a pretrial sworn affidavit and statement. Those affidavits and statements are just supposed to be about someone's identity. And it's just because Donahue went along with you doesn't mean it's okay. That's what he's trying to say. Oh, he knew there was no court order and he was all right with it. So what I did was okay. We can fix it later. But I sure did get it out in the newspaper, didn't I? And then they turn it around and talk about, oh, the public accusations against my client. Mace has inequitably used her publicity to try petitioner's principal in the court of public opinion. Did you get permission to video those women? Did you get permission to drug them and assault them? And now you want to talk about it's not fair? It's inequitable? There's very little about being a woman that's fair. That's for sure. Mace, and you know what? Somebody would have shut her up. She talked for hours. 4 hours. You can find the entire video. It's like 4 hours long. Nobody stopped her. If she had been doing something wrong, surely it would have been stopped. Mace is using these public allegations to fundraise and is benefiting from publicity, as is Doe. Well, do you know what happened to these women? This is sickening. While simultaneously and inequitably arguing in their briefs that it is petitioner who is improperly benefiting from publicly shaping the jury pool. Sick, sick, sick. And so this is what the judge decided. In the meantime, now this takes till September the 29th. So it seems like, hey, judge, she asked you to expedite this and you took 2 months to do it. But then we find in the course of his order, because he really lays out carefully, we can see he starts with the first date, with her speech. And he kind of goes through like how judges do to give the whole background of the case. But we find out that he has, since he received that motion, he has been eliciting evidence from both sides to put all this together. So he wasn't ignoring it. He was getting evidence from them, and they knew that. So undoubtedly they would have had to have stopped using those subpoenas, because they can't be used in court anyway, and now they know they're in trouble. And he withdrew it. I kind of already discussed this, but I was talking about how the more people try to get by using these things, the more word gets out that you can do this, the more I'm afraid people are going to keep doing this. And what kind of underhanded, despicable things are they going to do? It's a flagrant abuse of legal process. Okay, so here's another thing he did. So he asked for all this evidence, and he's going to have an in-camera review. And we've learned about that with this case. And so that's what he's been doing all this time, collecting this evidence. And he finds out that, as they feared, Wesley was not the only witness. But in fact, subpoenas and notices for deposition were given to 3 different people. Now, he does go through, and the other 2 people are not named. In the end, they don't get deposed, but they get asked not just for depositions, but look, all communications, calls, voicemails, emails, text messages. And again, there's no one here that has looked at that and been able to say, oh, you need to narrow that scope down. That's too much. You can't just have the entire contents of this person's phone, which is another reason why there should be a court, or where there has to be a court order to mind all of that stuff. And the other thing he did, if you look at the top right in green, he changed a number in the case number on the documents so that it wouldn't be traceable back to this case, because that's all it takes is one number difference. So that's what he did. For all of these things that he didn't want the court to see what he was doing, he put the number wrong. The stuff he actually wanted to file, it was filed correctly. But just these ones that he was trying to keep secret from the court, he puts this whole different number. Just so tricky. And it goes on asking what the others, but they don't end up doing their deposition, so we're not going to spend a lot of time on that. Here's what this judge found. He said, can the interveners intervene even though the petitioner unilaterally dismissed the action? That's the first question that needs answered. And 2, did petitioner's counsel violate the requirements of Rule 27 and or otherwise pursue unauthorized discovery to such a degree that sanctions are warranted under Rule 11? The court finds that the answer to the first question is inconsequential. He's like, that don't even matter. And that the answer to the second question is yes. So the judge is like, this is wrong. Yes, you can be sanctioned. Yes, you're going to be sanctioned. So he says that the issue of intervention is difficult, if not impossible, to evaluate based on the face of Rule 27 because petitioner failed to clearly allege the nature of the claim as required by Rule 27. As a threshold matter, petitioner should not be permitted to use its own failure to comply with Rule 27 as a basis to avoid intervention. While the allegations of the petition are unclear, the evidence makes clear that the major focus of Bryant's efforts both before and after filing the petition was to investigate, to pursue possible claims against Representative Mace. For example, on October 17th, well before the petition was filed, Bryant was actively investigating claims against Representative Mace and collecting witness statements. Bryant had already received sworn statements. Also, expected litigation would result in the subpoena and depositions of several witnesses, including Mr. Donahue. So he knew this was coming, and this is what he did, just like Blake did. And the judge is not fooled in the slightest little bit by it. It is Vanzan. Ocean, it is Vanzan. And I don't know what's going on about cow farts, but I wish I was in that conversation. But the time is I knew this would be long, but so I'm trying to get through it. Listen to these things. Contrary to petitioner's claim that the goal of the petition was only to identify the alleged unidentified victims who may have claims, petitioner's post-petition activities indicate the goal of the petition was in furtherance of investigating claims against Representative Mace. These subpoenas were issued. They focus on Representative Mace, just like Blake. There is little effort made through these discovery vehicles to identify potential victims or claimants. The totality of the circumstances would suggest that it is likely proper to allow Representative Mace and perhaps Doe to intervene. The court may consider, and then he talks about why it's okay for him to consider sanctions because this is a weird situation. So there isn't precedent for him to follow. But he's like, I have my inherent authority. And then he lists reasons that sanctions may be imposed for bad faith, willful disobedience, or abusive conduct, even after dismissal. So he's like, it doesn't matter that he dismissed it. What matters is that he acted in bad faith, willful disobedience, and or abusive conduct. This is how any judge should view these abusive Doe lawsuits. He says sanctions are warranted because this rule for Doe lawsuits is that depositions before action or pending. It was modeled from the corresponding federal rule, which I showed you earlier. It has been consistently held that it is not a method of discovery before suit is brought. That's how this guy used it. That's how Blake used it. The petition at issue here fails to meet the plain requirements of Rule 27 in several respects. First, the petition was not verified. Second, the petition was filed in the name of GLT2, or Vanzan, shall we say, rather than Bryant. And there is no reasonable basis to support that in the few hours between the entity's creation and the filing of the petition that GLT2 had acquired a claim or expected to be party to litigation. The petition failed to identify any of the witnesses petitioner proposed to depose, despite the evidence indicating that at the least, petitioner knew of witness one before filing the petition. So they're like, you knew Wesley Donahue, just like Blake knew Stephanie Jones. This is Vicky Ivy. Thank you, Vicky. The root of all this looks very Deadpoolish. It does. The court finds that counsel knew or should have known its petition was insufficient, but proceeded regardless. These judges, these people think they're going to fool them. I think that in both cases, they thought that they were not going to be caught. They thought they were going to do that. That's why he changed the case number. That's why Blake put it in Vanzan. They really thought they were going to get this stuff and not get caught. And then in her in her little footnotes explaining how she had this information. Do you remember? I talked about this a lot because it drove me crazy. I said it probably in 10 different videos, that she said she obtained these through legal procedures, including a civil subpoena. And I'm like, what subpoena? In order to have a subpoena, there has to be a lawsuit. What lawsuit? And she should have said, why did she never tell the court this Vanzan action filed on this day in this court? Why did she keep that all a secret? Because I think she thought and hoped that she was never going to have to say where she got it. If additional witness statements were necessary before it was possible to file a petition that complied with Rule 27, then it follows that Rule 11 dictates the petition should not have been filed. So don't bring it to the court if you're not ready. The facts do not support the assertion that there was a genuine desire to amend the petition to bring it into compliance. For example, petitioner issued subpoenas for documents and depositions to witness 1 on February 24th and Donahue on March 23rd. This was only a matter of days after filing a petition on February 20th and well before the first scheduled hearing on April 3rd. Not only does this issuance of these subpoenas demonstrate that petitioner had identified these potential witnesses, the substance of these subpoenas also makes clear that petitioner believed Representative Mace to be a potentially adverse party, because that's all what the questions were about. Yet at no time did petitioner supplement or amend the petition in an effort to bring it into full compliance with Rule 27. Exactly. As soon as you learn the name, you're supposed to amend the paperwork, put the name on there. But he's saying he goes after this witness within days of filing the petition. So how is he going to say, I don't know their names? How did he learn the names in those few short days? Prior to Mr. Donahue's deposition on April 28th, petitioner had learned the names of several persons who could be potential DOE claimants. It's ridiculous to believe that. The court was never informed of these potential adverse parties or given the opportunity to appoint these parties counsel for Mr. Donahue's deposition as contemplated by the rule. Exactly, Ocean, because they knew how illegal this looks. And then Ryan Reynolds filed as CEO of Vanzan like the day after Lyman dismissed the case. I don't know how he thought that was smart, what his intention was to that. To me, it makes it look more suspicious because it was really a stretch already for Blake to have done it. But Ryan, who had no part in the movie, why was he filing a subpoena like this? And how is Vanzan going to say they didn't know the name of the company or person that they had the contract with? Exactly. If pre-suit depositions are desired, the rule plainly commands petitioner shall ask for an order authorizing the petitioner to take the depositions. That's how it goes in a DOE lawsuit. You petition the court has to grant your order before you get that subpoena. The fact that petitioner issued subpoenas for depositions before even attempting to secure an order permitting the depositions demonstrates that the purported desire to bring the petition into full compliance with the rule was not genuine. I cannot wait. I really and truly hope that when a judge, whether it be Lyman or whether they file the Vanzan case in another court, whichever, I really can't wait to see what that judge has to say about this obvious abuse of process. And then, as they often do, there's a lot of repeated stuff that he issued the subpoena before the order. We've read that. More about Rule 27. The assertion, I love this part. The assertion, listen up, Blake stands, especially those of you who claim to be attorneys, that nothing in Rule 27 prohibits counsel for a petitioner and counsel for a deponent from reaching an agreement for the witness to give sworn testimony without a court order, that is incorrect. The requirements of Rule 27 to give notice to all interested parties and obtain a court order prevents exactly that. Despite attempts to characterize it otherwise, Mr. Donahue's deposition was not taken pursuant to an agreement. The problem before the court has nothing to do with whether or not Mr. Donahue was willing to do it. That has nothing, that's what he's telling them. It has nothing to do with it. Here, counsel for petitioner appears to have knowingly filed a deficient petition, as well as issued various subpoenas for depositions which had not been sanctioned or ordered by the court, as required by Rule 27. By signing and issuing these documents, petitioner's counsel triggered the requirements of Rule 11. And so he grants these sanctions. And then he says that that would be ordered separately. That was an interim. That was so he could let them know his decision immediately. Then it took a little time to come up with the actual amount of sanctions. Some of them were not submitted in time, or there would have been even more. But he does end up allowing the full amount of attorney's fees for Jane Doe and $15,000 for Representative Mace. You know what? I feel like I could talk about this case in a separate one. This is a whole nother case to go through. All right. I worry. You know what? I might cut it later, edit it later.